Okay, we're going to talk about our Chapter 3 topic, wills. That's on page 20 of your book. We've got, so the right to make a will is based in statute, right? So first of all, what is a will? It has three basic elements. It's in writing, signed by the testator and in their name, and then signed by two witnesses. And these are people who are acknowledging that this person is signing this of their own free will, that they have the ability to sign. And if it doesn't meet these requirements, it might still qualify as a will under the holographic will definition. And there are some things that can make a holographic will, other things that can't. So that's in your reading. Who can write a will? So there's a lot of talk about capacity. So who can write these things, and at what point do you lack the mental capacity to sign? Making a will is one of the lowest mental capacities required compared to some of these other things like making contracts and giving gifts. So the only thing required by law for someone to be able to execute a will is, let's see, where was it again? Yeah, to know the objects of your bounty, understand the nature of the property, and have the ability to instruct how those assets are distributed. So knowing the object of one's bounty, it's a little tricky, right? If someone can't even say, I don't know who my kids are, I don't know what property I have, that kind of stuff, probably not going to qualify. But if they can identify their basic assets, they can identify their family relationships and who they want to receive the property, and then who is going to or who is going to implement their wishes, that's usually sufficient. And there's a lot of gray area in between. Some people will lose capacity to do this on some days, and then some days they're doing better. Especially when they're in that kind of transition state in cases of dementia and Alzheimer's. And sometimes it's kind of sudden, where after a stroke or brain trauma, they suddenly lack that capacity. And so we have to be very careful as far as who has capacity when. Self-proving affidavits are one way to avoid having witnesses need to testify in court as to some of these things. So that's at the end of the will usually. The witnesses sign an affidavit. Affidavit means sworn statement, right? They just sign the sworn statement stating that that the person who signed has the ability to sign on their own, and that that language is provided here in your text. Who may be a witness? Right. So historically, if someone was going to receive property under the will, they couldn't serve as a witness, but some of that has changed. It's still best practice to avoid that, but it's not going to automatically invalidate a will. Some of the nuances are there in your text. Other documents referenced. So sometimes people have multiple personal effects, and they don't want to change their will every time they change their mind as to who's going to receive this property. So that's where this personal property memorandum comes in. They can designate who's going to receive that. It's referenced within the will, but it's a separate document, and it can be changed from time to time without having to change the will. No contest clauses. This one's interesting, okay? So in your text we have these penalty clauses, or no contest clauses, talked about on page 26. And it's a way to avoid litigation. So it basically says, anyone who contests this will be disinherited, right? However, in practice, and this is not in your text, but in practice, these clauses there was a survey of Utah probate court judges about 2 years ago, maybe 3 years ago, and they asked, how often do you uphold these clauses? And in the aggregate, they found it was about 1 in 200 times. So out of the 200 times that someone tries to enforce this clause and disinherit someone who contests the will, only in one case did they actually did the court allow them to disinherit them. And I think that's for a lot of reasons. Number one, because just by having the clause present, a lot of those suits that would have been frivolous never came forward. And two, in the statute, it allows, if you have a good faith claim, meaning there is a true reason for concern in contesting the will or contesting the estate, that notwithstanding any no contest clause, the courts will not enforce it if it was a good faith claim. So because of that, only 1 in 200 cases that went before probate court judges in the state of Utah were actually enforced against the contester. Okay. Trusts and wills, these are called testamentary trusts because they occur within the will and they're created within a will. This is basically an authorization to create the trust as part of the estate. Revocation or invalidation of a will can be revoked in writing, right? So if someone's signing a new will, usually it'll say, I hereby revoke any previous wills I've executed. It can be revoked by an act. So whether that's physically or symbolically, burning the will, tearing it up, anything like that. Or by change in circumstances. So there's 2 cases where the change in circumstances is really going to invalidate the will. So the first is if the testator was killed. This is someone who was killed intentionally. It's not necessarily homicide. And you'd cover some of the nuances here in your criminal law class, but it's basically what was it? It's essentially a felony homicide, excluding some of the vehicular homicides and things like that. But as we said in the footnote here, the burden of proof is actually preponderance of the evidence and not the beyond reasonable doubt. So they don't necessarily need to have been convicted of murder in a criminal court, but in a civil court, more likely than not, if it was more likely than not that this person killed the person, then their will's not going to apply to them. Okay. The second situation is where the testator gets divorced. Okay. So if the testator divorces and anything refers to a spouse or the spouse by name or an in-law, anyone who's related by marriage, the will is going to be invalid as to any of those relationships unless it specifically provides otherwise. So if it says, I want my brother-in-law to watch the kids after I'm gone, I get divorced, but my will says, notwithstanding any change in my marital status, I want my brother-in-law to watch the kids, then that's going to hold up. Okay, so you have to, it has to be express terms in the will. If someone passes away before the testator, it can get a little tricky. Sometimes we plan for that within the document, right? We'll say to so-and-so, but if they do not survive the testator, then maybe to this other person or to the deceased person's heirs at law. Anyway, so sometimes you can plan for it. If you don't, there's some procedures here in the code as outlined. And then finally, safeguarding the will itself. There are a few different ways to save the will. Some people will keep it in a fire safe at home. That tends to be the best place. You can put it in a safe deposit box at the bank, but the problem there is you need a court order to get into the safe deposit box. So it's anyway, it creates awkward situations. And then finally, you can deposit it with the court I have yet to see anyone do this, I don't recommend it. I have seen some attorneys will actually record wills and trusts with the county recorder. So they'll publicly record it with the county, but you've got private information in there usually. It's usually not the best way to do it unless there's a really unique reason why you'd want to do that. So that's our information on wills and covering Chapter 3 of your text.